Hi, I'm Lynsey Harrison, and I'm head of the Contentious Private Client team here at Clarion. And today I'm joined by Jacob, who's one of the solicitors in the team. Hi, Jacob.
Thanks, Lynsey. Good to be here.
And today we're going to be talking about the issue of proprietary estoppel. And that's a topic that seems to be cropping up more and more with a lot of the inquiries that we're getting, in particular in the agricultural sector, clients that are affected by it. Jacob, I know you in particular have been dealing with a number of inquiries from clients in the agricultural sector recently. And for some of them, this issue has come up and they were just completely aware of it as a thing. And we've had to sort of tease that information out of them when we've been taking those instructions. So for the benefit of anyone who is in that position, could you start by just giving us a really brief overview of what is proprietary estoppel?
Yep, of course. Proprietary estoppel is a legal principle in which someone is prevented from going back on a promise that they have made when the person who they've made that promise to has relied on that promise to their detriment, and it usually relates to a promise to give an interest in some land or some property. Typically we see it in farming cases where a landowner, usually a parent in the family, has made a promise to somebody else, such as the child in the family, and that child has then relied on that, usually through working on the farm for many years or the majority of their life for little or no pay, in the expectation that they'll receive the farm when the landowner dies, only to realise after the landowner's death that that's not the case.
Yeah, so you work really hard all your life and one day this will all be yours.
Yep.
And then it's not. Exactly, that makes sense. Okay, so if someone believes that they have a proprietary estoppel claim, what do they actually have to prove?
So there are three key elements to a proprietary estoppel claim. The first one being a clear assurance or promise. So this means the landowner must have given a clear and unambiguous assurance to someone, as I say, usually a child, that they will receive an interest in the property or land, and this can be verbally or in writing. The second element is reliance, so that person then must have relied on that promise or assurance through their actions. And the third element is detriment, so there must be some form of detriment suffered by that person through their actions in reliance on that promise. So usually in farming cases, again, it's the person having worked on the farm for all of their life.
Okay. And it's if all of those three conditions are satisfied, then that's when the court will intervene, won't they, to stop the landlord from going back on their promise, and to provide a remedy. And that's really helpful to go through it in that way. And when we're talking about remedies, what sort of remedies are there available?
Yep, so the court has quite a lot of discretion when it comes to remedies, and it can actually have the landowner or the landowner's estate transfer the land to the person who the promise was made to, or it might award a financial sum to the person. It really depends on the detriment suffered. So if it's a lesser sort of level of detriment, then smaller interests, such as a life interest in the property or the land, might be awarded.
Right, okay. So it's not necessarily an automatic right to ownership of the property, but the court will essentially aim to get a fair and reasonable resolution to the situation.
Yep, so they'll look at what the claimant expected, what was promised, and the sort of level of detriment suffered, and aim to provide sort of a just resolution or remedy.
And what are the sort of the common pitfalls when they're involved in this type of situation? What does a claimant face when they're bringing this type of claim?
One of the main pitfalls will be actually proving the promise or assurance. Again, back to farming cases, the family usually have informal discussions about inheritance and things being passed on to children, and nothing is typically documented or written down, and it's a promise that can be made regularly throughout the person's life, so they're rarely acting upon it, but when it comes to actually proving it, there's no written evidence. Also, issues with actually proving the reliance and the detriment can be a problem, because when the person may have worked on the farm, but say they received what could be interpreted as a reasonable wage, the court might look on that and say they didn't work purely on the reliance on the promise that they'd received the farm. They actually worked for the wage that they were receiving. Also, the landowner may just change his mind during his lifetime, and if the person defending the claim can give a good reason why, then that can also complicate things.
And that leads me to my next question, really, which is what is the practical advice that you would give to farming families to avoid this type of dispute in the first place?
Yep, so communication, I think, between the family members, and also, of course, documenting things is a big thing. So when these sort of informal conversations are taking place, which are very useful, I think having open conversations between the family members about succession planning is really important. But then to take that next step and actually document what is promised, document what's agreed, just gives everybody some clarity and can hopefully avoid disputes down the line. And for people who are actually relying on that promise, if they're going to devote their entire lives to working on a farm for little or no pay, then they should take legal advice to ensure that they're protected before they do that.
Yeah, totally agree. That's really useful advice. Proprietary estoppel claims can be really complex and difficult emotionally as well, can't they? So I'm guessing getting early legal advice and getting that preparation in place is absolutely key.
Yeah. Usually they are very emotionally charged. Obviously, it's disputes between family members, but also it's often the case somebody's died as well, which is what's sort of set things off. So actually putting things in place beforehand can prevent a lot of problems. And we're, of course, always happy to have a chat should somebody feel like they may have a proprietary estoppel claim. Yeah. We also have a private wealth team who we work closely with, and they're always happy to have a conversation about succession planning, hopefully to avoid the need for any dispute resolution down the line.
Thank you, Jacob. That was a really insightful discussion, and you've explained it in a really clear way. So thank you very much.
No problem.
Thank you. Thanks for watching. And as always, if you or anyone that you know has come across a situation like this and needs some help, please do get in touch. Thank you.